Today we're going to be talking about the new final Part 2 rules governing substance use disorder records, the confidentiality of those records. My name is Kim Stanger. I'm the head of our firm's Health Law Group. Happy to speak with you today about these particular issues. A couple of preliminaries. You should have received a link with the presentation materials if you would like those, along with some other helpful resources. If for some reason you did not receive those, you can just contact Charles at the website there on the screen, and he can make sure that he gets those to you. In our discussion today, I'm going to focus really on the application of the rules to healthcare providers, not necessarily government agencies or other entities that may be seeking orders or things like that to obtain these records. So I'm going to be looking at it from the healthcare provider standpoint. As I've gone through, I'll talk about what the changes are, but then I'll put those in context as we talk about the rules in general. I've tried to highlight the significant changes to the rules in red so that you can see those. If you have any questions as we're going through, you're not the only ones, but feel free to submit those. We're recording this program, and because we're recording it, we're not going to take questions. But if you have questions, you can go ahead and submit those to me using the chat feature, or you can simply email me, and I will do my best to respond offline. With that said, let's get into these records and the confidentiality rules. When we're talking about these rules, though, it's really important for you to realize that these are not the only potentially applicable rules. You got to look at all of the potential statutes that kind of overlap sometimes when dealing with the confidentiality of these substance use disorder records. Certainly, you've got to look at the statute, which was amended by the CARES Act back in 2020 or 2021. You've got to look at the new confidentiality regulations. That's what I'm going to be focusing on today. But you've also got to be concerned about HIPAA, the information blocking rule. Maybe your own particular state has special laws that apply to SUD records that you have to be concerned about. The bottom line here is when you consider all of these records, you really need to look at the most restrictive law, because you're going to have to comply with the most restrictive law. So if in most cases, 42 CFR Part 2 is more restrictive than HIPAA, but not in all cases. And it may or may not be more restrictive than the other state or federal law. So just remember that when there's a conflict, you have to comply with the most restrictive law. Now, this final rule was actually implemented to try to coordinate the rules concerning substance use disorder programs, at least on a federal level, with HIPAA. So there wasn't so much conflict. So the CARES Act required the government required HHS to implement these new rules that try to coordinate the SUD records, the rules concerning SUD records with HIPAA. The final rule was issued on February 8th. It takes effect on April 16th. However, it's not going to be enforced for another 2 years after that. So you've got 2 years to really comply with at least the specific requirements of that. But you can't put off the compliance that long because you still have to comply with HIPAA and the current Part 2 rules. So you still need to pay attention to it. What are the major changes in the final rules? Well, the big change, the most significant change is, in general, you have to get a written consent to use or disclose the substance use disorder records. Under the new rules, though, it allows a single consent for all future uses and disclosures for purposes of treatment, payment, and healthcare operations, or TPO. We'll use that reference throughout this. So that makes it a little bit easier and more consistent with HIPAA. It also allows HIPAA-covered entities and business associates that receive the records under such a consent to redisclose those records consistent with the HIPAA regs. They don't necessarily have to comply with the more stringent Part 2 regs, that if they're covered by HIPAA, they can comply with the rules for HIPAA when it comes to those redisclosures. It modifies patient consent requirements, which you've got to have in your consent in order to use or disclose the SUD records. It requires a copy of the consent to be provided along with a notice of the Part 2 obligations to the recipients of the information. We'll talk more about that later. It restricts the use of the records in civil, criminal, administrative proceedings against the patient, absent patient consent or a court order. It just makes express and makes it harder to use that information without the patient's consent or a court order in civil or criminal or administrative proceedings. It adopts HIPAA penalties and the HIPAA enforcement process for Part 2 violations. It adopts the HIPAA breach notification requirements for Part 2 violations. It requires a new patient notice, similar to a HIPAA notice of privacy practices, and it adds additional requirements that you've got to implement in the complaint process. That's kind of a highlight. Now we're going to talk about how that fits into the rules. So the whole purpose for these Part 2, the 42 CFR Part 2, the regulations concerning the confidentiality of SUD records, the government was concerned that people, it wants people to get SUD treatment if they need it, right? But people might be afraid to do that if that information is going to get out there into the public, might affect their job, might affect, other things. And so the government imposed these special requirements that apply to SUD records to minimize the impact and to make sure that the confidentiality is maintained. So in general, a Part 2 program and certain recipients of SUD records may not use or disclose the information that would identify a person as having had or having been referred for a substance use disorder unless either the person provides written consent or a separate exception applies. Now, throughout the regulations, they generally refer to an SUD record, but just realize that SUD record really means any information concerning a patient's substance use disorder, whether it's in oral, whether it's recorded or not. So instead of referring to SUD record throughout the slides, I generally refer to just SUD info because it's really broader than just a paper or electronic record. It really is any SUD information. Well, what happens if you violate Part 2? Well, under the old rule, it was a crime and you could get hit up with penalties, criminal penalties. Now, it was also probably a HIPAA violation for those covered entities who are Part 2 programs and also who are covered by HIPAA. But under the new rule, they did away with those old criminal penalties and they basically said, okay, the HIPAA penalty structure applies. So you may or may not know that under HIPAA, it actually has criminal penalties that can range from anywhere to a $50,000 to $250,000 fine and up to 1 to 10 years in prison if you disclose information without authorization. It depends upon your mens rea. Not too often. I mean, the government has gone after people for those criminal HIPAA violations. Usually what you see, though, are the civil penalties. And under the HIPAA civil penalty structure, which now also applies to Part 2 violations, if you act without willful neglect, the penalty is anywhere from $137 to about $67,000 per violation. If you act with willful neglect, however, it's a mandatory penalty of about $14,000 to about $69,000 per violation. The good news is if you don't act with willful neglect and you correct it within 30 days, then that's an affirmative defense to the civil penalties. On the other hand, if you act with willful neglect, it's a mandatory penalty that the OCR has to impose, and that structure now is also going to apply to Part 2 violations. The HIPAA enforcement process applies. That means that if there are complaints that they can turn you into the Office for Civil Rights. The Office for Civil Rights will usually come out and if there is a violation, they'll conduct their investigation. If there is a violation, they may ask you to engage in some kind of training. Sometimes they'll require settlements or agreements. And if it's bad, usually a situation where you fail to comply with the settlement arrangement, then they can impose those civil penalties. Usually you're not going to get the OCR knocking on your door. Instead, the more significant penalty is you're going to have to self-report breaches. Not only HIPAA breaches now, but also self-report breaches that violate the Part 2 regulations. All right, let's talk about to whom does this apply and what does it apply to? So the Part 2 regulations generally prohibits the use or disclosure of any information, whether it's recorded or not. So although it talks in terms of records, it's really any information, whether recorded or not, without the patient consent if the information identifies a patient as having had, or referred to a substance use, have been referred for a substance use disorder. And so it has to relate to SUD. In addition, it has to be created, received, or acquired by a federally assisted SUD program. That's really the crux here. Are you a federally assisted SUD program, or did these records, did this information come from a SUD program? SUD, or substance use disorder, is the cluster of cognitive, behavioral, and psychological symptoms, indicating that the patient continues using the substance despite significant substance-related problems such as impaired control, social impairment, risky use, and pharmacological tolerance and withdrawal. So if you are treating somebody or somebody has one of those, then the SUD potentially applies, but only if you are an SUD, a federally assisted SUD program. All right, so what does federally assisted mean? It's really broad. I mean, if you're participating in Medicare or Medicaid, you are a federally assisted program. If you have DEA registration, you're probably a federally assisted program. If you're a tax exempt entity, you're probably a federally assisted program. It's possible that if you are purely private pay, not getting any federal government money, then you may be exempt from this even though you're doing SUD treatment. But even in that case, if you're engaging in those electronic transactions, HIPAA is probably still going to apply, and you have to be worried about that. But for most of you are participating in some kind of federal program, so therefore you're probably federally assisted. And the real question is whether or not you are a program, because it only applies to federally assisted programs. What is a program? Well, a program is an individual or entity other than a general medical facility that holds itself out as a providing and actually provides SUD diagnosis, treatment, or referral. You know, a general medical facility is like a hospital, maybe a trauma center, FQHC, maybe a primary care clinic, kind of this general medical facility that provides a broad range of care. So the first test is, are you an individual or entity other, if you're not a general medical facility? If you're an individual or entity providing this service, are you holding yourself out as providing and actually providing SUD diagnosis, treatment, or referral? Now, if you're within a general medical facility, the program is that identified unit within that general medical facility that holds itself out as providing and provides SUD diagnosis, treatment, or referral. If you're medical personnel in a general medical facility whose primary function is providing SUD diagnosis, treatment, or referral, then you can also be an SUD program. So I like this chart. It helps me. So the way that it works, if you're an individual or entity, but you're not part of a general medical facility, well, then you're a federally assisted program. If you're a federally assisted, then you're a program if it holds yourself out as providing SUD diagnosis, treatment, or referral for treatment, and you actually provide that. If you're, on the other hand, within a general medical facility, that can be either an identified unit that holds itself out as providing the SUD diagnosis, treatment, or referral, and that actually provides it, or it could also be medical personnel or staff whose primary function within that general medical facility is to provide SUD diagnosis, treatment, or referral, and you are identified as such. So one of the key factors there is whether or not you are holding yourself out to the public as an SUD program or providing those types of services. Holding yourself out means that it's an activity that would lead one to reasonably conclude that the individual or entity provides SUD diagnosis, treatment, or referral for treatment. For example, through advertising or marketing, the SAMHSA FAQs, although I haven't gone back to check those since this new rule came out, but since this really hasn't affected by the new rule, I think it's still the same. In that guidance that they gave, they indicate that holding yourself out may include through state licensing procedures. So if you've gotten a state license that indicates that you're an SUD provider, maybe advertising or posting notices out there in the public that says, hey, come to us, we'll provide this SUD care, certifications in addiction medicine, listing in registries, internet statements, consultation activities for non-program practitioners, information presented to patients or families, basically doing the types of the stuff that says, hey, we specialize in this, we provide this treatment. It is not simply that you provide the treatment if you don't otherwise hold yourself out as providing that care. So for example, if you're an emergency room doctor, you may on a regular basis provide SUD type care, but that's not your main job. That's not what you're identified as. That's just part of the other care that you render. As a primary care provider, you may provide some SUD care, but as long as you're not holding yourself out as a specialist, as providing that, you're not advertising that as your practice, then you're probably not going to be a program covered by Part 2. Now, if you're in a general medical facility, the Part 2 program is that part of the facility, that identified unit or those identified individuals who are holding themselves out as and providing that SUD treatment. It's not the rest of the facility. So it's not like the whole hospital. It's just that identified unit. So it's that unit that has to comply with Part 2. And that unit, though, needs to make sure that if it's sharing that information out with the the whole hospital or the entity outside those outside the Part 2 program that is complying with the Part 2 rules. Now, so the first test is the rules apply to Part 2 programs, but it also applies to certain recipients of SUD information that may come from those Part 2 programs. Specifically, the confidentiality requirements generally apply to entities with direct administrative control over the Part 2 program, a qualified services organization, I'll talk about that more in just a minute, lawful holders, I'll also talk about that, persons receiving Part 2 information from a Part 2 program, if they're a Part 2 program or they're a covered entity, business associate, or intermediary, or a lawful holder who are essentially notified of the prohibited, notified that the Part 2 rules apply to them, and it prohibits redisclosures under the notice that has to be required, has to be given under Section 2.32. We'll talk more about that a little bit later. It also applies to third-party payers to whom records are disclosed by a Part 2 program or per the patient's written consent, and any person receiving SUD info in any civil, criminal, administrative, or legal proceeding against the patient if such information was obtained from a Part 2 program, a covered entity, or a business associate under HIPAA, or an intermediary or other lawful holder. So even if you're not a Part 2 program, you may still have to comply with the Part 2 rules limiting your use or disclosure or redisclosure of that information if you fit within one of these criteria, including if you're a qualified service organization or you're a lawful holder. Well, what is a qualified services organization? It's a business associate for a Part 2 program. A QSO it provides services for the Part 2 program, such as data processing, collections, dosage prep, lab analysis, etc. And it has to have a written agreement with the Part 2 program, like a business associate agreement, by which that QSO agrees to comply with Part 2 when dealing with the SUD information from the Part 2 program. And as part of that agreement, it has to agree that if necessary, it will resist judicial proceedings to obtain the SUD information unless the disclosure is otherwise required by applicable law. For example, that there's a Part 2 order that's been issued consistent with the regulations. As amended by these final rules, a QSO also automatically includes any business associates of the Part 2 program if the Part 2 program is a covered entity under HIPAA. So just think of a QSO, it's basically a business associate, right? If you as a Part 2 program are going to engage this other entity to perform services involving SUD information, you need to have a QSO agreement with them, and that QSO agreement has to require them to comply with Part 2 and to resist judicial proceedings. Well, what is a lawful holder? Well, the QSO, you have this agreement in place, right? And the Part 2 program can disclose information to its QSO without a consent from the patient. A lawful holder is a different type of entity. A lawful holder is an entity that is bound by Part 2 because they have received SUD information as a result of one of the following: that the patient gave a written consent, because of that written consent, the Part 2 program disclosed that information to this lawful holder, and the Part 2 provider, the entity that's providing this information, they give a copy of that written consent to the recipient and this notice of disclosure alerting them to the Part 2 requirements. Once you receive that, then you became a lawful holder and you've got to comply with the scope of that consent and that notice of disclosure. You've got to comply with the Part 2 regulations as applicable. Now, it can also apply, so the first way it applies to you, you become a lawful holder if that disclosure is made per the patient's consent, plus you get that notice of disclosure alerting them to the requirements, or it also applies to an entity, they become a lawful holder, if the disclosure is simply made under one of the exceptions by which, so that the disclosure can be made without a written consent per Part 2. And we'll talk more about that a little bit later. Now, lawful holders, once they get that information, they've got to comply with the Part 2 requirements. The requirements will allow them to disclose or redisclose SUD information, but only under limited circumstances. And those generally may depend in part on whether the holder is a Part 2 entity, whether it's a covered entity or business associate under HIPAA. All right, we'll talk more about that a little bit later. Now, what about if you're a healthcare provider, you're not a Part 2 provider yourself, but you get Part 2 records? What do you got to do with that? Well, if you receive those pursuant to the patient's written consent, because the patient can give written consent to disclose that to other providers, in fact, they generally have to, and you get that with a notice, then you're a lawful holder. If what you have to do with that information then depends on these rules, that if the SUD information is disclosed orally to that non-Part 2 provider, that non-Part 2 provider may record the information in its records, and Part 2 would not apply to that non-Part 2 provider's records, right? If they got the information orally and they just recorded in their own notes, Part 2 won't apply to those records. On the other hand, if they get Part 2 records in writing and they want to incorporate that into their records, then generally Part 2 requirements are going to follow those records, and those records are still going to be subject to Part 2. If the non-Part 2 provider doesn't want to have all of his records subject to Part 2, they need to segregate those Part 2 records from the rest of their other records. All right, now part of the new rule, there's new rules that apply if you're a recipient of the information for purposes of treatment, payment, or healthcare operations. Under the new rules, the most significant and helpful portion of it, it allows Part 2 providers to get a single consent from the patient that allows them to use or disclose the protected health information for purposes of treatment, payment, or healthcare operations, as those are defined under HIPAA, without having to go back to the patient and getting a separate consent each time. So if you are a Part 2 program, you're a covered entity or a business associate that's covered by HIPAA, even if you're not a Part 2 program, and you receive records based on that single consent for disclosures for TPO purposes, then in that situation, you're not required to segregate those records. So not all of your records become Part 2 records if you are getting those records for purposes of treatment, payment, or healthcare operations. The theory there is that, you know, you already have to comply with Part 2 and HIPAA, and therefore, because you already have to comply with HIPAA, then they don't have the same concerns about you using or disclosing those records. All right, let's talk about the confidentiality rules. As I mentioned, the Part 2 generally prohibits the use or disclosure of the information, whether it's recorded or not, without the patient's consent if it is created, maintained, or obtained by a Part 2 program, and it identifies a patient as having had or been referred for a substance use disorder. It is kind of like HIPAA, right? It applies to any individually identifiable information, name, address, social security number, photos, or any other identifiable information, right? It's like HIPAA. It would not apply to de-identified information. The new rules allow you to de-identify information consistent with HIPAA standards, in which case the Part 2 rules would not apply at that particular point in time. Just like with HIPAA, any use or disclosure of SUD information, you generally have to limit that information to the amount that which is necessary to carry out the purpose of the use or disclosure. It's similar to the minimum necessary standard, but not precisely the same, because under the minimum necessary standard under HIPAA, there are exceptions for like disclosures for treatment purposes and the like. Those exceptions to the minimum necessary standard don't appear to carry forth into the Part 2 stuff. So you got to make sure that you're using the minimum necessary. Remember that those confidentiality requirements apply even if the person seeking the information already has it or may obtain it elsewhere. The fact that it's public record doesn't make a difference. You still can't use or disclose it, just like HIPAA, right? Doesn't matter that the person already has it. Doesn't matter that the police show up, they know the patient's in your facility. You still can't disclose the information unless they jump through the hoops. Doesn't matter if the information is sought by law enforcement or another government agency, or the use or disclosures for civil, criminal, administrative, legislative proceedings by the federal, state, or local authority. No matter whatever in those situations, you still got to have the patient's consent, or they have to fit within a specific HIPAA exception, or excuse me, a Part 2 exception that will allow you to use or disclose that information. That applies even to queries about whether or not the patient's at your facility. Remember, under HIPAA, you can generally disclose whether a patient's there under the facility directory exception. That is not the case with Part 2. Under Part 2, you may not even acknowledge the patient if the facility is publicly identified as a place where the SUD diagnosis, treatment, or referral for treatment is provided, because doing so would, definitely indicate that the person has an SUD, right, if they're in your facility. You can't do that unless the patient consents or you obtain an authorizing court order per Part 2. You may acknowledge the person's presence if the facility is not publicly identified as an SUD facility and the acknowledgement doesn't indicate that they're there for SUD. So if they're there just as a general, at a general hospital that's not limited to being an SUD facility, and you don't otherwise disclose them as receiving SUD, you could acknowledge their presence there, but you can't do it and give any information that would indicate that they're there for SUD. Now, if the person shows up, you may answer a request for SUD information. You can't answer it in a way that will not affirmatively reveal the patient has been diagnosed or is being diagnosed or treated for an SUD. So you couldn't, for example, if they show up, you couldn't say, I can't disclose that information because the patient is here for an SUD. And Part 2 prohibits it. You can simply give the requester a copy of the Part 2 regulations and state that they restrict disclosures of the SUD information, but you cannot affirmatively indicate that that's why you're giving it for this particular patient or state it in such a way that indicates that the patient is there for an SUD. All right. So when it comes to the disclosure of SUD, the general rule is you've got to have the patient's consent. For treatment, payment, or healthcare operations, generally you can get one consent, if the patient will sign it, one consent that applies to all future uses or disclosures for treatment, payment, or healthcare operations unless the patient revokes it. For other purposes, you've got to have a specified written consent unless you fit within one of the exceptions that allow you to make disclosures without the patient's consent that we'll talk about in a few minutes. Let's talk first about the requirements for a consent. In order to satisfy Part 2, the consent for use or disclosure has to satisfy certain requirements. Some of those is changed in this final rule. You've got to have the patient's name, the names of or the specific identification of the persons making the disclosure, the description of the information that is going to be disclosed. You've got to identify recipients. I'm going to talk about that more in just a minute. You've got to include a description of each purpose for the disclosure, the basis for making the disclosure so the patient knows why you're making it. You can simply say if the patient's the one who wants the request, the disclosure, you can simply say at the request of the patient, or if it's for treatment, payment, or healthcare operations, you can simply say that. If the consent has to include the patient's right to revoke the consent in writing and explain how the patient may revoke it. Now, just like under HIPAA, if the Part 2 program or the lawful holder has acted in reliance on the consent, then the patient may not revoke that consent retroactively. They can only revoke it for information created thereafter. It's got to contain, that consent has to contain an expiration date or event that relates to the patient or the purpose for the use or disclosure, just like a HIPAA authorization. It's got to contain the signature or electronic signature of the patient or the person authorized to give consent under Part 2, and it's got to contain the date of the signature. Now, as part of that consent, it's got to identify who the recipients are. There are special rules for identifying the recipients. The general rule is you've got to include the specific name or classes of persons receiving the information. If you're going to get a single consent for all future uses for TPO, the recipient may simply be described as my treating healthcare providers or health plans, third-party payers, kind of a general one. That's okay if it's going to be that single consent for future uses of TPO. For intermediaries are entities that get the information to help process the information, like a health information exchange or maybe an ACO. If the disclosure is going to be made, you're going to get consent for disclosure to intermediaries. You've got to include the names of the intermediaries and the names of the member participants or description of those who participate in that entity who may get the information. But you've got to limit, those participants have to be limited to participants who have a treating provider relationship with the patient, not just everybody. If the recipient is a covered entity or a business associate under HIPAA, and it's disclosed for purposes of treatment, payment, or healthcare operations, you've also got to include a statement in the consent that states that that the patient's SUD information may be redisclosed in accordance with the HIPAA regulations, except for uses and disclosures for civil, criminal, administrative, and legislative proceedings. That basically just puts the patient on notice that if this is a disclosure for TPO, that under HIPAA, it allows redisclosure without the patient's consent to the extent allowed by HIPAA. So you need to make sure that the patient is advised of that in that consent requirement. Now, that's the general rules for what you got to have for consent. Under the, as amended, the final rule also has special rules for SUD counseling notes. SUD counseling notes are basically the same thing as psychotherapy notes under the context of HIPAA. It's not just any records concerning SUD, it's the notes that are prepared by the Part 2 program provider to help them generate like the medical record and the like. It's the notes from their counseling sessions that are separate and apart from the rest of the medical record. The SUD notes generally are used to prepare the record, but they're different than the record. SUD counseling notes are not medication prescription monitoring, counseling session start and stop times, modalities, frequency of treatment, progress notes, all of that type of stuff. Those are just medication records, right? Those are just the SUD records, the medical records. Those don't get the special protection like counseling notes. You treat counseling notes kind of like psychotherapy notes under HIPAA, which generally means that you can't disclose SUD counseling notes except to carry out certain TPO functions. You can't give, you've got to generally have a specific written consent for the use or disclosure of SUD counseling notes, and that consent can't be combined with any other written consent for the disclosure of other records. Part 2 program may not condition treatment payment or enrollment in a health plan or eligibility for benefits on the use or disclosure of SUD counseling notes. The bottom line is SUD counseling notes are a very limited, defined, specific term. A lot of you may not have any of those, but if you do have those get this special protection similar to psychotherapy notes, but it doesn't apply to kind of your general SUD notes. For the general SUD notes, you talk about those general rules that we just discussed. Under Part 2, you generally may not use the SUD information in any civil, criminal, administrative, or legislative investigation or proceeding against the patient, if it's against the patient, without the patient's written consent or a Part 2 order from the court. So they gave this special protection for criminal or civil proceedings. If you are going to get consent from the patient to use it in those proceedings, that patient consent for the use or disclosure in such proceedings cannot be combined with another consent for any other purpose. So you couldn't just use your general TPO consent for healthcare operations and claim that it's part of the healthcare operations. You would have to have a specific consent for that purpose. If you have a defective consent, you can't rely on it. A consent is defective if it's expired or if it doesn't contain the required elements, if you know that the patient's revoked it, or if you know that the information in it is materially false. That basically tracks the similar HIPAA authorization rules. Now, so let's say now you've got this patient consent that it goes ahead and allows you to make this disclosure to a third party. HIPAA says, or the Part 2 says, okay, you can go ahead and make it, but when you make that disclosure, under the new rules, you've got to give a copy of that consent to the entity receiving the disclosure, or either a copy of the consent or a clear explanation of the scope of the consent so they understand what the scope of their use is going to be. And in addition to a copy of the consent, you've got to give them a notice. That notice puts them on notice that, hey, this stuff is covered by Part 2 and what your responsibilities are. You have two options for the notice. You've got the long form, you've got the short form. The short form just simply says you can give them a notice that says 42 CFR Part 2 prohibits the unauthorized use or disclosure of these records. That's fine, you can go ahead and use it. On the other hand, you may want to give them more complete notice because it will advise them, give them more information about the scope of the Part 2. And so you just have this form that whenever you send out these records pursuant to the patient's written consent, including disclosures to other treating providers and the like, you'd send them a copy of the consent, plus you'd give them a copy of this notice. Presumably, in the long form may actually be more helpful to them. It has to track this language in the new regulations, and that language has changed. So you'll want to update this notice when you are sending those Part 2 records out. As I mentioned, one of the major benefits of these new rules that if the patient can give this single written consent for all future uses and disclosures for treatment, payment, or healthcare operations. If they give that, then a Part 2 program covered entity or business associate may use and disclose those records for such purposes as permitted by HIPAA until the patient revokes such consent or in writing. So The theory there is, hey, these entities are covered by Part 2, they're covered by HIPAA, they're going to use this information appropriately, so you can go ahead and those entities can go ahead and use that for TPO functions without having to get a separate consent each time. If, on the other hand, if the patient gives a specific written consent, the Part 2 program has to limit any use or disclosure of that SUD accordingly. And if they're going to use it differently, they need to go back and get a different consent. There are some special rules that apply to disclosures to central registries or in conjunction with criminal justice referrals. I'm not going to discuss those today, but just make sure that you're aware of those. All right, so we've talked about getting the consent and the disclosure to the recipient. What about the recipient's ability to disclose it to third parties? Can that recipient who gets this written consent and this notice, can they disclose it to third parties? Well, the rules differ depending upon the type of entity that receives that. The general rule is if the patient gives a written consent for the use or disclosure of their records, the recipient may further use or disclose those records as follows. Under Part E, which is basically if you get the court order, right, or some certain limited exceptions, but those are pretty limited. The general rule is, these rules are the ones that apply, that if that information is disclosed to for TPO to a covered entity or a business associate, then that recipient may further disclose that information in accordance with HIPAA, okay? So HIPAA applies directly to covered entities or business associates. HIPAA limits their use or disclosure of that the information for treatment, payment, or healthcare operations. So Part 2 basically says, okay, if you're covered by HIPAA, then you can go ahead and use or disclose it to the extent permitted by HIPAA, but that's only if you're covered by HIPAA. There is the exception, however, for any use or disclosure for civil, criminal, administrative, or legislative proceedings. Remember, again, for that, you generally need the patient's consent or one of those special court orders. So even if you wanted to claim that that was for use under healthcare operations, for example, you would still need the patient's consent for use or disclosure in those civil, criminal, or administrative proceedings. All right, so that's the rule if it's a disclosure for a TPO to a covered entity or business associate. If, on the other hand, it's disclosed for all future TPO activities to a Part 2 program that is not a covered entity or a business associate, so HIPAA does not apply, then in that situation, that recipient may further disclose those records, but only consistent with the consent. So they have to comply with the consent requirements. In that situation, Part 2 applies, but HIPAA doesn't apply, so you don't get the broader protections. The recipient has to limit their use or disclosure consistent with the terms of the consent. If it's disclosed for payment or healthcare operations to a lawful holder that is not a covered entity or business associate, for that lawful holder is not covered by HIPAA, then the recipient may further disclose those records as necessary for its contractors, subcontractors, or legal representatives to carry out functions for healthcare, for payment or healthcare operations specified in the consent, but not for others. So you need to make sure in that situation, again, that lawful holder is not covered by HIPAA, the information is not protected by HIPAA, and therefore Part 2 says because it's not protected by HIPAA, we need you to comply with these Part 2 requirements. Generally, that lawful holder cannot further redisclose that information unless they satisfy certain requirements. These are the requirements. Any of those lawful holders who wish to redisclose the patient identifying information for payment or healthcare operations, they've got to essentially get a written agreement with the recipient of that, by which that recipient acknowledges that Part 2 applies. They're going to agree to comply with the Part 2 stuff. They're going to put in place appropriate safeguards to protect that information they receive. And they've got to report any unauthorized users or disclosures of that information. Generally, that lawful holder may only redisclose that information to the extent necessary for it to perform its functions on behalf of the contractor, and it limits any redisclosures to any third parties. So just, if you're a downstream party to this, you are the recipient of that information, you're limited in your ability to disclose those further down the chain. There are certain rules when it comes to prescription drug monitoring programs. Generally, even prescription drug monitoring programs, to disclose SUD information as part of a prescription drug monitoring program, you generally have to have the patient's consent, and you've got to make sure that the disclosure is required by state law. Simply to make the disclosure per state law is not enough. you've got to generally have the patient's written consent prior to reporting that information. Part 2 trumps contrary state law. There are special rules if you want to make a disclosure to prevent multiple enrollments. Part 2 does allow you to make disclosures in certain circumstances for that. If you've got a situation where a patient is enrolled in a criminal justice program and their enrollment in your SUD program is part of their condition of, say, probation or the like, then Part 2 will allow you to go ahead and make those disclosures to that criminal justice program, but only if the patient signed a consent and the disclosure is limited to those who need to know. So in those situations, you're going to probably want to make sure that the patient, you condition your provision of services on behalf of the patient to the patient signing that consent that allows you to make those disclosures. All right, so those are the general rules for disclosures with consent. Remember, the general rule is if you're going to use your disclosed SUD information, you got to have the patient's written consent. There are certain circumstances where you can make disclosures without the patient's consent. You can disclose or communicate within the Part 2 program, but you have to limit it to those who have a need to know. You can communicate between the Part 2 program and the entity with direct administrative control over the Part 2 program. So if, for example, if the Part 2 program is run by a hospital, then you could disclose the information as to the minimum necessary to those who have direct administrative control over the program. You can disclose communications with a QSO so long as you have that QSOA, the QSO agreement. You can make reports to law enforcement of crimes or threats that are committed on the program premises or that are against program personnel, but you've got to limit the information to the circumstances related to the incident, such as patient names and addresses, patient status, whereabouts, etc., but not necessarily provide more information than necessary concerning the SUD. You can disclose the information as necessary to report child abuse or neglect to the extent that's required by state law, but you generally cannot disclose the actual SUD records unless the entity jumps through the hoops in order to get a Part 2 order from the court requiring that disclosure. You can make a disclosure in the case of a medical emergency if you can't get the patient's consent before that. But in that situation, you've still got to document in the disclosure in the medical record immediately afterwards the information that you disclosed and to whom you disclosed it to. Note that under HIPAA, you generally can use or disclose the information without the patient's authorization for purposes of treatment, payment, or healthcare operations without the patient's consent. That's not the case under Part 2. So Part 2 limits your disclosure even for treatment purposes unless you can fit without the patient's written consent, unless it's a medical emergency. HIPAA or Part 2 would allow you to make certain disclosures to entities that are performing audits on behalf of government agencies, third-party payers, a QIO, and the like. The rules differ depending on whether the records are copied or removed from the Part 2 program. Generally, if the patient consented to disclosures for healthcare operations, you have them sign that one consent that allows disclosure for healthcare operations. This would generally be considered healthcare operations, and you can go ahead and make disclosures. The bottom line, though, is when it comes to audit, pull out 42 CFR Part 2.53 and make sure you're jumping through the right hoops. When it comes to criminal, civil, or administrative actions, again, the rule is you can't use SUD records in any federal or state civil, criminal, or administrative proceeding or investigation unless you have either the patient's consent or you get hit up with an order and a subpoena that satisfies the Part 2 requirements. Police may show up there. They may claim that you're obligated to. They may claim under state law you're obligated to. You're obligated to tell them, no, I can't unless I get the patient's written authorization or the written consent, or you go to court and you get this special kind of order under Part 2. Those orders, that special orders, it's a special process. Just getting a subpoena signed by a court's not enough. Just getting an order signed by the court's not enough. In order to allow disclosures for these proceedings, you've got to have both a court order, and it has to address certain things, plus you've got to have a subpoena that authorizes that disclosure. The court can only issue that order under certain circumstances, the criteria that's set aside up there. The regulations have a specific process that has to be followed, including it has to be a confidential process, there has to be a petition, there has to be a hearing, then the court has to issue an order and a subpoena in order to get that information, and it's got to limit that order and subpoena has to limit the disclosures to certain stuff. Bottom line is, if you get an order or you get a law enforcement or an entity that tries to get you to disclose that information per garden variety subpoena, that's not enough. You'd have to tell them, no, here's the Part 2 rules. You have to comply with this. If you do get that order, you'll want to look at the Part 2 rules to make sure that the order complies with these rules. All right, let's talk quickly about minors. So similar to HIPAA, under Part 2, if a minor may consent to their SUD care under state law, then generally the minor controls the disclosure of their SUD information. So if they're competent to consent to their own health care, their own SUD care under state law, then they also control their information. And that means you generally can't disclose that information to the parent or guardian without the minor's consent, including disclosures to obtain payment. So under HIPAA, you could generally make disclosures to the parent or guardian as necessary to obtain payment, right? So long as you haven't agreed otherwise. That is not the rule for Part 2. For Part 2, you generally cannot disclose to parent without the minor's consent, including for payment. So what you're going to want to do is, before that patient shows up, that minor shows up to get care, you're going to want to have them sign the consent that allows you to use or disclose the information for treatment, payment, or healthcare operations. Otherwise, you're going to have a hard time getting paid. The rules specifically say that you can refuse to provide the care to the minor unless that consent is given. Now, if the minor may not consent to their care under state law, then generally, this differs a little bit from HIPAA. You may not disclose the minor's request. So if the minor just shows up and wants to seek care from you, you can't disclose that, but you're not going to provide the care. You still can't disclose the fact that the minor requested care to the parent and guardian unless the minor gives you written consent or the minor lacks capacity to make rational decisions. It's not enough just that they're a minor, that they have to lack capacity to make rational decisions. Any consent for disclosure to others must be given by the minor and the parent or guardian. So even though you need parent or guardian consent, you still have to get consent from the minor before you can make disclosures to any other entities. You may disclose the facts relevant to a substantial, if a minor shows up and there's concerns that there's a substantial threat to the minor or to other third person, and you determine that the minor lacks capacity to make rational decisions, then you can go ahead and make that disclosure even though you don't have the minor's consent, if it's necessary to reduce substantial threat to the well-being of the minor or another person. Well, what about adults who lack capacity? Well, if there's been a court determination that the adult lacks capacity to make their own decisions and the court has appointed a separate personal representative, then that personal representative can give you the consent or refusal. So you rely on that. If the court has not determined that an adult patient lacks capacity to make their own healthcare decisions, the Part 2 program director may consent on behalf of the patient solely for the purposes of obtaining payment for a third party so that you're not left out in the cold. Otherwise, though, it's kind of a bit of a quandary. The patient lacks capacity, you can't get consent. You've got this information, but until a court-appointed guardian has been appointed, a court-appointed personal representative, you're limited in your ability to make disclosures in those situations. What about deceased persons? Well, Part 2 still applies to records of deceased persons. You may disclose the cause of death consistent with state laws for reported vital statistics. For other uses or purposes, written consent generally has to be given by the deceased patient's personal representative. All right. Part 2 also gives patients certain rights concerning their information. Among other things, you can't require patients to carry an identification card off-site, because if that patient is found or they lose it, it would identify the patient. You can require them, however, to carry an identification card on site. Part 2, unlike HIPAA, Part 2 does not generally entitle the patient to receive access to their records. HIPAA might, and most of the time you're going to be covered by HIPAA, so you still have to comply with the HIPAA rules. But Part 2 does not expressly require you to give the patient access to the records. It says you may, but it doesn't expressly require you to do it. There is no consent required to disclose the information to the patient. Would be kind of silly if that were the case. The patient, under the new rules, remember, you can use or disclose the protected health information for treatment, payment, or healthcare operations so long as you get a single written consent by the patient allowing you to do that. The patient's not required to give you that consent, but they can do it if they want to. When they give you that consent, the patient could request that you restrict the uses of disclosures of treatment, payment, or healthcare operations to the scope of what they've requested, but you're not required to consent to those restrictions. So kind of like HIPAA, under HIPAA, a patient has a right to request restrictions on use or disclosure for treatment, payment, or healthcare operations, but you're not required to agree to that. The one exception to that is if the patient pays for their episode of care themselves, then they can instruct you not to make disclosures to the health plan related to that particular encounter for which they've paid the payment in full on their own. That's the same rule under Part 2 now as it was under HIPAA. Now, even though you're not required to agree to the restriction, if the Part 2 program does agree to the restriction, then you've got to comply with that agreement unless it's an emergency and you need to make the disclosure. If you can cancel that restriction, but you have to cancel it prospectively, and the restriction would still apply to any of the records that were generated while the restriction was in place. Under the new rules, under HIPAA, of course, the patient has a right to receive an accounting of disclosures. The new Part 2 rules affirm that in the Part 2 context. Under the new rules, upon request, a Part 2 program must provide the patient with an accounting of all disclosures made with their consent. Under the consent was given under 2.31 for the prior 3 years or such shorter time as chosen by the patient. So under HIPAA, you don't have to account for disclosures made for a patient's authorization. That's not the case under Part 2. You've got to account for even disclosures made with the consent. That accounting must generally follow the requirements under the accounting of disclosures for HIPAA, including the name, date of the recipient. You've got to provide it within no later than 60 days after the request, unless you get an extension. You can't charge them for that during a 12-month period. You've got to maintain the documentation along the way to enable you to provide that accounting if it's requested. Now, when it comes to disclosures for treatment, payment, or healthcare operation, under HIPAA, you don't have to currently make those disclosures for treatment, payment, and healthcare operations. However, under Part 2, if you maintain an electronic health record, then you do have to make those disclosures that were made for treatment, payment, or healthcare operations during the prior 3 years. Now, that's what the rule says, but they've also indicated that they are tolling that. You don't have to do that until HHS issues the new HIPAA regulations that would enact that requirement for electronic health records for everybody. So just be aware that that's coming down the pipe, but you don't have to worry about it immediately. The patient also has a right to get a list of disclosures by intermediaries. Intermediaries are those persons other than a Part 2 program, covered entity, or business associates who've received records under a general designation and a written patient consent to be disclosed to one or more of its member participants, who has a treating provider relationship with the patient. So it would be like a health information database that would allow disclosures to treating providers. That's the intermediary. Under these accounting rules, upon request, the intermediary has to provide the patients with a list of persons to whom that intermediary has disclosed the patient's records during the prior 3 years. Under the rules, under the new rules, the patient has to you've got to establish a complaint process. The patient has a right to file the complaints. They can submit that complaint to both the Part 2 program and HHS. You can't intimidate, threaten, or get the patient, somehow require them to waive their rights to the complaint process. They have the rights to do the complaints. All right, the next one, and a big one, is under Part 2 now. You have, in the past, have had to give the patient a notice of the confidentiality obligations, but now the government has given you a lot of specific information that you've got to include in that notice. It's similar to, but not precisely corresponding with your notice of privacy practices that you would have to give under HIPAA. The Part 2 notice of privacy practices has to contain a whole bunch of stuff. It has to contain this specific header with this information. It's got to describe the uses and disclosures and gives you information concerning what you have to describe for each. It's got to summarize the patient rights and specify these rights that the patient has. It's got to describe your program duties that you owe to maintain the confidentiality. It's got to explain the patient's right to file a complaint and how they can get that done. It's got to include the name, title, and telephone number of a contact person that they can contact to get more information. It's got to have an effective date and notice. And that notice, that's the effective date for that notice of privacy practices, and you're going to have to comply with that privacy practices after the date of that notice until you issue a new notice. You've got to, in addition to providing that notice, you've got to explain to the patient the right to filing a complaint. You've got to include the name or title of the contact person. You've got to, when you issue that notice, the Part 2 program, if you're going to make revisions to it, you've got to revise and distribute a new notice if there is a material change in the practices or duties. And you can't implement new changes before distributing that new notice unless that changes or the new practices are required by law. Think of that notice as kind of a contract with the patient, that this is, you're telling them how you're going to comply with, how you're going to treat their information, and therefore you can't change that unilaterally until you give notice to the patient. You've got to make that notice available to any person or the patient upon request. You've got to provide that notice, like HIPAA, no later than the first date of service. So if you're providing those services first electronically, you got to set it up so that you provide that notice electronically. If you maintain a physical delivery site, you've got to post that notice at the prominent locations. If you maintain a website, you got to put the notice on the website. You may provide the notice by email if the patient agrees to that. And you've got to provide a paper copy of the notice if the patient requests it. The CARES Act actually has anti-discrimination provisions that prohibits entities from taking discriminatory action against a person because of SUD, but the final rules did not include those. We have to wait for those new rules to come out. The security rules, under the new rules, they basically emphasize that Part 2 programs have to put in place specific policies and procedures to protect the security and privacy of their information. Those policies and procedures have to be formal written procedures that cover certain specific items that are set forth in the regulations. Those regulations generally also have to apply and have to extend to lawful holders, except that those standards don't apply to family, friends, or other informal caregivers who are lawful holders. They don't have to come up with their own written policies for maintaining confidentiality. Part 2 does not get into all the specific granularity that HIPAA does when it comes to security rules, but remember, most of you, if you're a Part 2 program, you're also going to be covered by HIPAA, so you still have to comply with the HIPAA security rules. Under the new rules, they specifically confirm that a Part 2 program that has a breach, that the HIPAA breach notification rules apply. So you, as a Part 2 program, even if you're not otherwise covered by HIPAA, you still have to comply with the breach notification requirements, including the notice to the individuals who are affected, plus the notice to HHS. The Part 2 has specific rules when it comes to if you're going to close your Part 2 program or you need to dispose of your records. They have specific rules that apply in how you do that. All right, that is a summary of Part 2 along with those new rules. Just a quick checklist of some of the things you need to be doing before February 26, 2026, when these new rules become effective. Remember, don't put off your compliance because you still have to comply with HIPAA. If you're covered by HIPAA, you still have to comply with the current Part 2 rules, which are the guts of the Part 2 rules anyway. So you can't ignore this stuff for the next 2 years, right? It's just the changes that take effect in 2 years, but you still have to comply with the existing rules. You're going to want to, immediately determine to what extent Part 2 applies to you and to the other entities to whom you do business. Do you have QSOs? Do you have lawful holders? And what do you need to do in order to maintain your relationships there? You need to review and, if needed, modify your processes for disclosures of SUD information within and outside your organization. You're going to want to identify your QSOs and update your QSO agreements to make sure that they are consistent with the new rules. That likely means that you're just going to have to update your current existing business associate agreement with them, but you need to make sure that that business associate agreement contains the new requirements. Now, that may, your arrangements with the QSO may require you to review and maybe renegotiate or terminate or change those current agreements to ensure you're complying with the new rules. You're going to want to review and, if necessary, update your HIPAA risk assessment to make sure that you're protecting your information consistent with Part 2 as well as HIPAA. Review and update your privacy and security policies. Again, you probably already have that for HIPAA. You're just going to want to make sure that those policies are consistent with the Part 2 requirements that are set forth there for policies. You're going to want to draft and implement new patient consent forms, including you're going to want to use a consent that allows you to use or disclose protected health information for TPO on a one-time consent. So you're going to want to modify your consent policies. You're going to want to review and update that notice that has to accompany that consent when you're making disclosures to the consent. So you'll want to use the updated statements. You'll want to draft a new notice of privacy practices shortly before those confidentiality rules come out. Don't give it out before it becomes effective, right? Because then you're going to be bound by it, but you're going to want to have it, make sure that it's ready to go. The government has said that they are going to be issuing new regulations talking about relevant to HIPAA and notice of privacy practices. So you can wait until you get those new regulations. The government's indicated that they'll issue more guidance once they issue those new HIPAA rules. You're going to want to review and draft and implement policies concerning the patient rights, including their complaint processes, their right to access information to the extent it exists, their right to request restrictions, the accounting of disclosures. Again, that's going to be coordinating with your existing HIPAA policies. Then you're going to want to train staff on all of those things. All right, that is a quick summary. If you need more information, you can go to the SAMHSA website. They've got helpful information concerning the new rules, as well as the interpretation and application of the old rules. Among other things, they've got, and I provided you with their fact sheet, the commentary that accompanied the new rules themselves. All of that's available through the sites that I gave you in my presentations. If you want additional information on Part 2 or other information, HIPAA and the like, we've got a bunch of free information available on our website. There's free content that you can access that, including recorded webinars, including this webinar. If you need to use it for training or the like, it will be recorded, hopefully, and available on our website shortly. Other than that, thank you very much. Appreciate your participation in the webinar today. If you have questions, feel free to shoot those to me using the chat feature or the email. Otherwise, good luck.